Good day, sir. I am Jane Ignacio. I'm about to recite the Rule 115 to Rule 120. Rule 115, Right of the Accused. Section 1, Right of the Accused at Trial. In any criminal case, the accused has the following right. First, presume innocent. The accused is innocent until proven guilty beyond reasonable doubt. Second, right to be informed. They must be told clearly what they are being accused of. Third, right to be present and have a lawyer. They can attend all parts of the trial and have a lawyer. If they run away or skip court without a valid reason, they may lose the right. Fourth, the right to testify. They can speak in court as a witness for themselves, but they will also be cross-examined. Staying silent cannot be used against them. Fifth, right against self-incrimination. They cannot be forced to testify against themselves. Sixth, right to confront witnesses. They can question the people, testify against them. Seventh, right to call witnesses. They can bring in their own witness and evidence. 8. Right to speedy fair and public trial. The trial must not be delayed, unnecessary, and must be fair. 9. Right to appeal. They can challenge the verdict if allowed by law. Rule 116, Arraignment and Plea. Section 1, Arraignment process. Arraignment happen in court where charges are read in a language the accused understand. The accused must be there personally to enter a plea, guilty or not guilty. If they refuse to plead or give a conditional plea, a not guilty plea is entered. If they plead guilty but present excuses or reason is changed to not guilty. If in jail, preventive detention, arraignment should be happen within 10 days after the case is assigned. The private complainant victim must attend arraignment, especially for plea bargaining. Arraignment should be done within 30 days from the time the court gets jurisdiction over the accused. Section 2, Plea to lesser offense. The accused can plead guilty to a lesser offense, a lighter crime included in the original charge, but only with the permission from the court, the prosecutor, and the victim. Section 3, Plea of guilty to capital offenses. The court must make sure the accused fully understand what pleading guilty means. The prosecution must still show proof, and the accused can also present evidence. Section 4, Plea to non-capital offense. For lighter offenses, the court may or may not require more evidence before giving a sentence. Section 5, Changing a guilty plea. The court may allow this accused to change their guilty plea to not guilty before the final judgment. Section 6 to 8, Cry to a lawyer. The accused must inform the accused of the right to a lawyer. If they can afford one, the court must appoint a competent lawyer, counselor, or the official. The appointed lawyer must be given time to talk to the accused before arraignment. Section 9, Bill of Particulars. The accused can ask for more details about the charges before entering a plea. Section 10, Request for evidence. The accused can request to see important evidence that the prosecution has to avoid surprises. Section 11, When arraignment can be delayed. Arraignment can be postponed if the accused is mentally unfit to understand the charges. There are prejudicial questions to legal issue in another case that affects this one. A review of the prosecutor decision pending maximum of 60 days delay. Rule 117, motion to quash. Section 1, when to file. You can file a motion to quash as to cancel the case anytime before pleading guilty or not guilty. Section 2, how to file. It must be in a writing, signed by the accused or lawyer, and must clearly state the reason. Only stated reason will be considered, except lack of jurisdiction. Section 3, grounds. You can ask to squash if A, what's charged isn't a crime, B, court has no power over the offense, C, court has no power over the accused, D, prosecutor had no authority to file case, E, complaint information is defective, F, more than one offense is charged, G, crime or liability has been erased, H, there's a legal excuse for the act, I, accused was already acquitted, convicted, or case was dismissed before. Section 4, amendments. If the complaint can be fixed, the court may allow corrections. If the error doesn't describe a crime, the prosecutor is given a chance to fix it. Section 5, if granted, the court can order a new case to be filed. If not, or time expire, the accused may be released if not facing other charges. Section 6, not always final. Even if the motion to quash is granted, new charges can still be filed unless the reason is double jeopardy or the crime has been extinguished. Section 7, double jeopardy. It can't be tried again if you are acquitted or convicted proper court. The case was dismissed without your consent after arraignment. Exceptions. You can be tried again if a more serious crime was discovered later or happened after the first charge. Section 8, provisional dismissal. Cases can be dismissed temporarily only with the accused consent and notice to the victim. For the minor crimes, become permanent after 1 year. For serious crime, becomes permanent after 2 years if not revived. Section 9, waiver. If you don't file a motion to quash before pleading, you lose your right to raise certain objection like lack of jurisdiction or double jeopardy. Rule 118, free trial. Section 1, mandatory pre-trial. The court must schedule a pre-trial within 30 days after arraignment to discuss plea bargaining, agreement on facts and evidence marking, objection to evidence, any changes in the trial procedure, other matters to speed up the trial. Section 2, agreement. All pre-trial agreements must be in writing and signed by the accused and lawyer. If not, they can't be used in court. Section 3, no-show. If the prosecutor or defense lawyer doesn't attend without a valid reason, the court may penalize them. Section 4, pre-trial order. The court will issue a written order showing what was agreed and marked. This controls what happened during the trial.